And for more on Trump's hush money trial and his presidential immunity case before the Supreme Court, let's turn now to federal defense attorney Ronald Chapman. Ronald, great to see you again. I want to talk about the witnesses that the defense called. Rona Graff, who worked for the Trump Organization for over 3 decades. Gary Farrow, a former senior manager at First Republic Bank. What did we learn from these testimonies, in your opinion?
Well, honestly, it didn't advance the case much, but we don't expect that to happen so early. Generally, prosecutors have to make sense of the case, which means often they have to have witnesses that are just providing a foundation for certain aspects. The fact that Trump had a telephone number, the fact that Michael Cohen wired money. These are things that ordinarily we think we wouldn't have to spend time proving, but in a prosecution you actually do. That being said, I think the most bombshell testimony came from Pecker when there was an admission that the hush money payment was made for the purpose of influencing the election. That's what the prosecution wanted to get out of his testimony, and I think they secured that. That being said, it still doesn't get you to the level of a felony offense. They have much further to go in terms of proof.
A lot of legal analysts agree with you there. I was interested in Graff's testimony. She's been Trump's former assistant for a long time, over 30 years. Did she come across as credible in the courtroom?
Well, obviously wasn't there in the courtroom, but from what I've heard on the reports in terms of credibility, I mean, it seems that that's the case. We've got somebody who has a close relationship with Donald Trump, somebody who was relatively well organized in terms of gathering factual information and knowing people. And I think that's the case. I do believe there was some cross-examination on the fact that at least McDougal might have been a contestant for one of Trump's shows. So perhaps the reason that the information was there may have been not related to the affair. But let me just turn the page to another topic related to that, and that is the issue of credibility. Trump's counsel during opening statements denied the existence of these relationships. I feel like that went a bit too far. You don't need to defend Donald Trump's character during this trial. You need to defend the fact that this is not considered a felony offense. And I feel like perhaps getting into that battle caused these needless issues in the case.
Well, now I'm really interested to hear what you thought about David Pecker's testimony. He, of course, is the ex-publisher of the National Enquirer. He was questioned for 10 hours. What was so interesting to me is he said, this is common practice. We've done this with politicians. We've done this with Hollywood stars. Why do you think the prosecution was trying to establish that with his testimony? Like, this is just another day for publications like the National Enquirer.
Well, you know, I think that they have to, because they want to get some of the bad information for their case out front. They knew that Trump's counsel was going to go into that and show that this is very common. But I think there's also a very important interplay going on here, and that is, from my understanding, they captured the McDougal story but declined the Stormy Daniels story. And as a result, that's when Michael Cohen gets involved, wires the money. And I think what the prosecution was trying to show here, which was very interesting, is that they structured the McDougal deal in order to get around campaign finance laws. But I think the argument here is that they didn't do that same thing with the Stormy Daniels story. So we thought McDougal was just going to be another case of catch and kill and unlawful conduct. But what they're doing is comparing the two to show why the Stormy Daniels payments were different.
So we're down 1 week. In your opinion, how did Trump's legal team do cross-examining Pecker as a witness? Again, that was 10 hours of testimony.
10 hours of cross-examination. It's substantial. I think they scored a few points. Honestly, I think that the issue here is that the prosecution isn't moving the ball forward. It really does seem to be a trial searching for a crime. And the reality is, I think that the more the prosecution does this, the more the jury is going to say, are we really just relitigating 2016? Or are we actually moving forward into proving criminal conduct? And that'll be on the jury's mind by the end of the case if the defense does their job.
I only have about a minute, but I want to talk about the Supreme Court justices hearing arguments Thursday from both sides regarding the presidential immunity. What can we expect there?
Well, you know, I'm surprised that I've heard a lot of people say that immunity is a tough question. It seems to be a very easy question from the court. Gorsuch said that this is a case for the ages. And what this really means is our country right now is a fork in the road. If the Supreme Court denies presidential immunity, we will have every president battling litigation, criminal charges for the foreseeable future. As Sauer pointed out in opening, Obama with the drone strike, and then President Bush with WMD, they might have faced criminal charges if this new era is opened up. The reality is the Supreme Court will grant some form of presidential immunity, and Trump's case will hinge on whether or not his acts were considered official acts.
We'll be watching this very closely. I know you will too. Ronald Chapman, thank you.
Thank you.